19-year-old Karmelo Anthony has officially entered Texas State Prison custody to begin his 35-year murder sentence for the tragic track meet stabbing of Austin Metcalf. As his legal team moves toward an appeal, the public conversation has shifted completely. People on social media are asking, what does life look like for him behind bars right now? How does the Texas intake system actually work for a young inmate? And what kind of environment is he facing? Today, we are ignoring the rumors and staying strictly on the facts. We are breaking down the objective reality of his first days in state custody, what the intake process is actually like, how parole eligibility works under Texas law, and how his family and loved ones are navigating this new reality. Let's look at the truth. If you want to understand the real legal mechanics behind these tragic headlines, please subscribe to U.S. Crime Cases right now and follow our updates. Now, to really understand what is happening right now, you have to look at the process. When a defendant is sentenced to state prison in Texas, they do not just immediately walk into a permanent cell block. I see a lot of people assuming he just went straight to his long-term housing, but that's not how the system operates. Their first days are entirely about processing, identification, and evaluation. Following his conviction in the trial court, reports say Anthony was transferred from local custody into the Texas Department of Criminal Justice system.
Prison at age 19.
This transition marks the official end of the local jail phase.
This timeline outlines
Think about
his
it.
35-year
County jail
sentence.
is local.
There is no
it is where
guarantee
you
of
wait
parole
for
in
trial.
Texas.
But state prison custody is the beginning of actual penal custody. The intake process is a highly standardized mechanical system. It is designed to identify who the inmate is, document their condition, and decide where they fit within the state's prison infrastructure. Personal clothing is taken away, state uniforms are issued, a TDCJ identification record is created. From that point forward, the system no longer treats him as a defendant waiting for trial. It treats him as a convicted inmate serving a sentence. During these initial days, the facility functions as a diagnostic and classification hub. New arrivals go through intake before permanent placement decisions are made. TDCJ rules also show that intake and early custody rules can affect when certain visits become available. The schedule is completely out of your hands. It is controlled by institutional staff. According to prison procedures, the process includes medical and health screenings. The state has to identify any pre-existing conditions, injuries, or immediate medical needs because, legally, they are now responsible for managing his health while he is in custody. Following that physical health screening, the state also reviews mental health and safety needs. Staff assess whether a new inmate needs additional monitoring, treatment, or special placement. I mean, wow, you have a 19-year-old just handed 35 years. The state knows that is a serious adjustment period. This phase can also include educational and background reviews. The state collects this data to determine if an inmate requires placement in specialized programs, basic education, treatment services, or a different custody setting. They also screen for safety risks, gang concerns, and possible victimization risks. Then comes a major component of these first days: security classification. Texas prison officials use classification rules to determine where an inmate should be housed. This evaluation looks at the nature of the current crime, the length of the sentence, past criminal history, behavior while in custody, age, and safety concerns. Because Anthony is 19 years old and serving a 35-year sentence for a murder conviction involving a fatality, his security profile will be reviewed closely. The state uses this classification data to determine the custody level and housing environment that fits the inmate. Higher risk factors can lead to more restrictive housing decisions to maintain institutional safety and minimize conflict within the general population. The institution of the Texas prison system does not shield an offender just because of their youth at the time of the crime. Anthony was 17 years old at the time of the incident, but he was tried and convicted as an adult. So he enters the state system alongside adult offenders. He will spend the next part of his life in prison custody instead of living the normal outside life most people expect at 19. That is the numeric reality of a 35-year sentence. A huge part of his young adult life has now been legally taken over by the state. While this cold bureaucratic process unfolds inside the facility, the underlying legal record remains fixed outside. And to truly understand how he got here, we have to look closely at what happened. This decades-long sentence was the direct result of a short physical escalation under a stadium tent. To remain strictly balanced and fair, we have to look at the actions described in court records and trial reporting. We have to center the victim here. Austin Metcalf was just 17. He had a loving family, a future, and his life was permanently cut short in a matter of seconds. We must respect that immense loss and understand the grief his family is navigating every single day. According to police, court records, and trial reporting, the incident happened during an April 2025 high school track meet in Frisco, Texas. There was a sudden rain delay and students moved under a pop-up team tent to stay dry. That is where the altercation started. Reports from the trial say Anthony was under a tent connected to another school's team area when Austin Metcalf confronted him and told him to move. The state presented evidence that Metcalf and others wanted Anthony to leave the area. Prosecutors argued that Anthony brought a concealed knife to a public school event and used it during the confrontation. They argued the stabbing was not justified and that it met the legal standard for murder. The police said the weapon was concealed, and the state said the violence was completely unjustified. But the defense argued something completely different. They argued that Anthony acted out of fear during a fast-moving confrontation. Defense witnesses pointed to claims that there may have been a push or physical contact before the stabbing. The defense attorneys argued that Anthony reacted in a split second during a chaotic moment, trying to defend himself in a crowded and hostile environment. However, the legal mistake that cost Anthony his freedom happened in the seconds immediately following that physical confrontation. Under Texas law, deadly force has to be tied to a reasonable belief of an immediate threat of death or serious bodily injury. Right, so think about it. The jury heard both sides. They heard the defense argument about fear and panic. They also heard the prosecution's argument that the response was not legally proportional. In the end, the jury did not accept self-defense. This brings up a really critical legal debate that people are having online right now. Was the 35-year sentence proportional? If an unarmed student initiates physical contact against a smaller student, does a decades-long prison sentence correctly weigh the shared fault of the escalation? I see both sides arguing this heavily, but the truth is found in the Texas legal standard. The judge gives the jury very specific instructions on how to read the law. The law requires deadly force to be a proportional response to an imminent threat of death or serious bodily injury. The moment Anthony used a deadly weapon during a physical confrontation, the self-defense argument became much harder for the defense to prove. Why? Because the prosecution argued the threat he faced did not justify deadly force. You cannot use deadly force in a confrontation unless the law recognizes the threat as serious enough to justify it. The jury ruled on the written law separate from the physical mismatch between the two teenagers. They looked at the statutes, they looked at the timeline, and they returned a guilty verdict for murder. To really understand the severity of this outcome, you have to look at the hard legal numbers governing Texas adult sentencing parameters. Because the conviction was murder and the case involved a deadly weapon, parole eligibility becomes a major issue. Under Texas law, certain serious offenses can require an inmate to serve 1/2 of the sentence, or 30 calendar years, whichever is less, before parole eligibility. The math here is brutal. On a 35-year sentence, half of that is 17.5 years. That means Anthony may have to serve roughly 17.5 years before he is even eligible for parole consideration. Good conduct time does not automatically erase that waiting period for this kind of parole calculation. If he keeps a clean record and survives the prison environment, the earliest parole review would still come when he is close to his late 30s. And we have to remember, eligibility does not mean release. It just means the parole board can review the case. The board can deny it, and serious violent cases are often difficult on the first review. For the Metcalf family, the court's strict application of the law brings a measure of accountability for the devastating loss of their son. They are dealing with a permanent void that no prison sentence can ever actually fill. For Anthony's family, it is also a devastating reality of losing their child to the prison system for what the defense called a split-second reaction in a chaotic moment. From the teenager's fatal choices under that tent to the strict application of state law, this was a tragedy that permanently altered multiple families. There are no winners here, just a deep, permanent tragedy that leaves us analyzing the heavy, irreversible consequences of a single fatal choice. Online, people are asking a really common question. Can a young inmate actually survive this kind of environment? I see this question popping up under almost every article and video about the case. It makes sense, right? You have a 19-year-old stepping into the adult Texas prison system. But the truth is that Texas state facilities are highly controlled operations. It is nothing like the outside world. A typical day in there is dictated by schedules, staff directions, head counts, and institutional rules. You do not get to decide when you sleep or when you eat. Inmates wake up according to the facility schedule, and that is followed by structured movement, meals, and counts. If you look at the physical layout of a Texas prison housing unit, it is built around control, visibility, and restricted movement. We are talking about secured doors, controlled day rooms, and monitored movement corridors. Security staff maintain tight control over movement to reduce conflicts and prevent unauthorized gatherings. The police said the original crime happened in a chaotic, crowded track meet setting. Well, the prison environment is the opposite. It is designed to reduce chaos through control. Think about the psychological shift that requires. One day you are a teenager attending a high school track meet, worrying about normal teenage things. The next, the state places you into custody and issues you a TDCJ identification number. The court said his actions legally warranted a complete removal from society for decades. That transition from civilian life to state custody is a heavy, shocking reality. For any young inmate entering this massive system, adjustment depends heavily on following institutional rules. You have to stay away from prison politics, you have to avoid unauthorized groups and conflict. Wow, just think about the mental discipline that takes for someone that young. The environment offers very little flexibility. Individuals must adapt to the rigid schedule set by the administration. Following the initial diagnostic phase, inmates are assigned based on classification decisions, housing needs, security level, and job placement. And once you are there, your daily routine may include institutional work or training assignments. What does that actually look like? The court said he is serving time, and the state system can assign work or training based on classification and institutional needs. Depending on the unit and eligibility, inmates can be assigned to facility operations, maintenance, food service, laundry, agriculture, manufacturing, or other work and training programs. Recreation is not the same as freedom. It is scheduled, supervised, and subject to security rules. If there is a lockdown, staffing issue, or security disruption, movement and recreation can be restricted. That is the reality. On social media, friends, relatives, and loved ones of Karmelo Anthony have expressed deep concern over how he will cope with all of this. It is a terrifying reality for a family to face. But as we talk about this, we have to center the victim. Supporters of Austin Metcalf's family emphasize that a long sentence is the necessary accountability for a lost life. Austin was 17. He was an athlete. He had a family that loved him. And because of a fatal decision under that track meet tent, his life is permanently over.
He must serve 17.5 years.
Right. We have to approach this with genuine empathy.
35-year sentence.
When we talk about the human experience here, we have to look at the ripple effect of that one afternoon in Frisco. Austin Metcalf had graduation ahead of him. He had a future his family expected to see. His twin brother later accepted his diploma on his behalf, and that moment showed the painful reality of what his family lost. I cannot even begin to imagine the strength it takes to wake up and face the world after losing a child like that. The community lost a friend, a teammate, and a son. Reports from the case describe the track meet scene as chaotic and traumatic for the students who witnessed it. Austin's parents do not get to visit him behind glass. They have to visit a cemetery. The court said the conviction was murder, and for the Metcalf family, Knowing that the person responsible is locked away in a strict, controlled environment is the only measure of justice the legal system can offer them. They have been very clear that they want accountability, and they want people to understand the gravity of what was taken from them. If you haven't subscribed to U.S. crime cases, hit that button now. We break down the absolute truth behind the headlines, keeping you fully informed. For Anthony's family, communication with their son is now completely altered. It is limited to approved phone calls, approved contacts, and scheduled visitation rules. I see people wondering if he can just call home whenever he wants. No, he cannot. TDCJ phone access depends on eligibility, custody level, disciplinary history, and approved calling lists. Visitation also depends on facility rules, scheduling, custody status, and whether the inmate is still going through intake. You cannot just walk in and see someone whenever you want. Every visit has rules. Every call has limits. Every contact is controlled by the system. If you have never received a call from a state facility, it is a very jarring experience. TDCJ phone rules state that calls are limited in length and all calls except attorney calls are recorded and subject to monitoring. Right when a family is trying to hold on to a serious conversation, the system still controls the time, the access, and the conditions. That is the reality of state communication. It is cold, it is monitored, and it is strictly regulated. When it comes to mail, privacy is also limited. TDCJ says letters to inmates must go through authorized channels, and regular mail is processed through the Digital Mail Processing Center for scanning and electronic distribution. Unauthorized materials or contraband can be rejected. You cannot just send anything you want to someone in state prison. The system checks it first to make sure it does not create a security issue. Meanwhile, people are constantly asking about parole and the actual timeline of the sentence. 35 years is a massive number, so how does it actually play out on the calendar? Under Texas law, certain serious offenses require an inmate to serve 1/2 of the sentence, or 30 calendar years, whichever is less, before parole eligibility. For a 35-year sentence, that means the key number is half of the sentence. Furthermore, inmates in this kind of sentencing category cannot simply use good conduct time to erase that initial parole waiting period. TDCJ explains that for certain assaultive offenses, good conduct time is not used to calculate parole eligibility. The court said 35 years, which means he has to serve the required calendar time before the first parole review. He can follow the rules, take programs, and avoid discipline. But that does not mean the initial parole eligibility date automatically moves forward. For a 35-year sentence, this legal framework means a minimum of 17.5 years must be served before the Texas Board of Pardons and Paroles can review the institutional file. So he is 19 now. He will be close to 37 years old before his file can come up for parole consideration. And it is really critical to note that reaching parole eligibility does not guarantee release. I think a lot of people misunderstand that. They think 17.5 years means he just packs up and comes home. Let me explain how that parole review actually works, because it is not what you see on television. The inmate does not automatically walk out because a date arrives. The parole process looks at the offense, the sentence, institutional behavior, program participation, risk factors, and input from people connected to the case. They look at the facts, they look at what the court said during sentencing. It is not a guaranteed second chance, it is a review. The parole board retains discretion to deny release based on the severity of the offense, his institutional behavior, and opposition from the victim's family or local prosecutors. Austin Metcalf's family can oppose parole and remind the board of the life that was taken and the pain that remains. If parole is denied, an inmate must wait for another review cycle. This means the actual time served can extend far beyond the initial 17.5-year mark. All of this heavy operational reality continues on a daily basis inside the facility, while his appellate lawyers work quietly on the legal challenge outside the prison walls. So while all of that strict daily routine is happening on the inside, his lawyers are working entirely on the outside. The appellate process operates separately from whatever is going on inside the prison walls. And according to Texas criminal appeal practice, a felony appeal can take months and sometimes even longer depending on the record, briefing schedule, and court timeline. Under Texas law, a person convicted in a criminal case has a right to appeal, but that right still has to follow the rules and deadlines of the appellate system. But I see a lot of people online misunderstanding how this actually works. When people hear the word appeal, they usually picture a dramatic movie scene. They think the lawyers get to go back into the courtroom, call new witnesses to the stand, or present some brand new piece of evidence that changes everything, right? That is not how a direct appeal works. An appellate court does not conduct a brand new trial. There is no jury sitting in the box. New witnesses are not called to testify, and new physical evidence is not simply introduced for the first time. Instead, the appellate process is mostly a strict record review. It is based on what already happened in the trial court. During the original trial, court reporters create a written record of what was said and done in the courtroom. They record jury selection, witness testimony, bench conferences, objections, rulings, and attorney arguments. The appellate defense team takes that record and reviews it page by page to identify possible legal errors made by the trial judge or constitutional problems that may have affected the proceedings. They are not simply arguing the case all over again. They are arguing over whether the legal rules of the trial were followed correctly. One major issue being discussed by Anthony's supporters centers on allegations of racial bias during jury selection. Specifically, the defense raised a Batson challenge after prosecutors struck potential black jurors from the pool before the trial began. Anthony is black and Metcalf was white, and the defense argued that the makeup of the jury raised serious fairness concerns. The appeal could ask a higher court to review that part of the record and decide if the trial court handled the jury selection challenge correctly. Now, the Metcalf family and the prosecutors have rejected the idea that race controlled the outcome of the case. Prosecutors denied that race played a role in the strikes and argued that the jurors were removed for legal race-neutral reasons connected to the case. The Metcalf family has publicly maintained that the trial was not about race. They have described it as a matter of accountability and law. During the trial, the judge sided with the prosecution and allowed the jury to be seated. But now, if this issue becomes part of the appeal, appellate judges can review the record and decide whether the trial court made a legal mistake. This appellate phase has also drawn a lot of attention to the financial mechanics of high-stakes legal defense. And wow, this part has really confused a lot of people tracking the case. Reporting says an online fundraising campaign raised more than $615,000 for Anthony's legal defense and related family needs. People saw that number and assumed the family was fully covered. But recent reporting also says Anthony filed a pauper's oath, which is a formal request for court-appointed counsel on appeal due to indigency. In simple terms, he told the court he could not afford an appellate lawyer. I see people asking how that is even possible. But you have to understand the immense financial pressure connected to a prolonged criminal case. Defending a first-degree murder charge can be extremely expensive. Private defense attorneys, expert witnesses, investigators, legal filings, trial preparation, and the cost of the official record can drain money quickly. That does not automatically prove anyone lied about the money. It means the court now has to look at the paperwork and decide whether he qualifies for appointed counsel. Under the law, when a defendant shows the court that he cannot afford counsel, the court can appoint an attorney to protect the constitutional right to representation. Furthermore, pursuing an appeal carries a major legal risk known as the retrial framework. A lot of people think an appeal is just a safe bet that you either win and go home or lose and keep your current sentence. But that is not always true. If an appellate court finds a serious legal error, the result is often not an automatic release. In many cases, the conviction can be reversed and the case can be sent back to the trial court for a new trial. While getting a new trial may be the objective of the defense, it can reset the legal clock. In Texas, if a conviction is reversed for trial error and the case is retried, the state can present its case again to a new jury. And here is the risk for a defendant. A new jury is not automatically bound by the first sentence. If found guilty again, the new punishment can still fall within the legal range for murder. That range can include a much harsher sentence, depending on what the jury or judge decides. So if he wins an appeal, gets a new trial, and loses again, the outcome could still be severe. Wow, think about the weight of that gamble. The discourse surrounding these first prison days highlights a really deep societal divide. On one hand, you have the profound, irreversible reality of the victim's family. Austin Metcalf never got the chance to grow up. He never got to graduate, go to college, or have the future his family expected for him. We have to center the victim in this conversation because his family is living a nightmare that they did not choose. For the Metcalf family, the prison conditions Anthony faces are the direct consequence of a fatal act. They don't get an appeal for their son's life. They don't get a retrial. Their loss is permanent. They have stated that the trial was a matter of accountability, and the 35-year sentence is the justice system delivering the consequence the jury believed was appropriate. On the other hand, others look at the reality of a teenager spending his youth inside a harsh state facility and question the broader impact of it all. Anthony's supporters look at the original confrontation, the chaotic environment, and the fact that he was 17 at the time, and they struggle with the reality of a decades-long adult prison sentence. These discussions raise serious questions that communities have to face. How should the justice system balance rehabilitation with severe punishment for young offenders? Can a highly regimented, restrictive prison structure successfully redirect a life, or does it simply warehouse people for years? Ultimately, looking at this case from the outside provides a sobering lesson for families everywhere. If we step back from the legal paperwork and the prison routines, this case is an urgent reminder for parents to actively guide their children. We must teach young people to reject bullying behavior, intimidation, and territorial aggression. But equally as important, we must teach teenagers never to bring harmful items or weapons into public spaces. The police said Anthony brought a knife to a track meet. The court said that choice escalated a physical confrontation into a murder conviction. An instant of anger, a short confrontation under a tent, escalated into an irreversible tragedy that destroyed multiple families. Let's encourage our teens to stay completely out of trouble. We have to teach them to recognize when a situation is turning hostile and to leave immediately when they feel unwanted or unsafe. Walking away is not weakness. It is the smartest thing you can do. It is the choice that protects your life and your future. This case leaves us with so much to analyze about the system. From a legal standpoint, I want to hear what you guys think. Should the standard for a fair trial require a jury to reflect the demographic makeup of the local community? Or is a randomized pool enough as long as no unlawful discrimination is proven during selection? And what about that retrial risk? Texas law can allow a new trial after a conviction is overturned, but that new trial can still expose a defendant to serious punishment if convicted again. Do you think this risk is a necessary part of the legal system, or does it make defendants afraid to challenge trial errors? Finally, when a defense team presents a sudden passion argument, should the judge always include it in the jury instructions and let the panel decide, or is it the judge's duty to block it if the trial evidence does not meet the legal threshold? Let me know your thoughts on the legal structure of this case and the Texas appeal process in the comments below. Keep the conversation respectful. Thank you for staying till the end. If you want more honest case breakdowns, please subscribe to U.S. Crime Cases right now. See you soon.